We are on the record on 23 CF 170, People versus Timothy Bliefnick. Mr. Bliefnick is present in court along with his attorney, Ms. Casey Schnock. People are present by Assistant State's Attorney Josh Jones and Laura Keck. And I am told the jury has reached a verdict. And Mr. Jones, anything before we bring the jury in?
Do you want to remind everybody to turn their cell phones off?
Yes, I guess I will. Ladies and gentlemen, you're allowed to have your cell phones in the courthouse. However, when you are in the courtroom, they must be turned completely off. That means completely off, not on silence, not on vibrate, not in airplane mode. They must be completely off because and they must be put away because if the security sees that you have your cell phone on or your cell phone goes off, you will be removed from the courtroom and will not be allowed back in today. That does not include the media, which of course are allowed to have their devices out so they can communicate with the public, but they need to be wearing their badges so that they are identified as media and so security will not hassle them. And then Mr. Jones, anything else before we bring the jury in?
No, Your Honor.
Ms. Schnock?
No, Your Honor.
Okay, let's bring in the jury.
Make seated.
All right, which juror has the paperwork? All right, juror number 6. I take it you are the foreman then?
Yes.
And has the jury reached its verdict?
We have.
Okay, and if you could hand that paperwork to the bailiff? Give it to the clerk. Would the clerk read the verdicts, please?
We, the jury, find the defendant, Timothy Bliefnick, guilty of home invasion signed by the foreperson and 11 jurors. We, the jury, find the defendant, Timothy Bliefnick, guilty of first-degree murder signed by the foreperson and 11 jurors. We, the jury, find the allegation that during the commission of the offense of first-degree murder, the defendant personally discharged a firearm that approximately caused death to another person was proven, signed by the foreperson and 11 jurors.
All right, thank you, clerk. And then, Ms. Schnock, would
Yes.
you like to have the jury polled?
No, Your Honor.
All right. Ladies and gentlemen of the jury, I thank you for your service. You will need to head back then to the jury room and wait there for just a couple minutes, and I will be in to talk with you shortly thereafter, all right?
All rise.
May be seated.
The court enters judgment on the verdicts And then the defendant has been held without bond. The court will continue holding the defendant without bond until sentencing. And we will pick a sentencing date.
Judge, from a scheduling purpose, if we could look for the first week of August, I believe. I'm sorry, the second week of August,
Second week of August, okay?
anytime between the 9th and the 17th.
Did you say anytime between the 9th and the 17th?
Yes, sir.
I can give you the afternoon of August the 11th at 1:30. I'll give you all afternoon. Do you think we'll need more than half a day, Mr. Jones?
I wouldn't think so, Your Honor. I assume we'll take up any post-trial motions and the sentencing.
We'll take up any post-trial motions, and I'll get to that in just a minute.
I would think the afternoon would be fine.
Ms. Schnock, do you agree?
That would be fine.
All right, and the 11th works for you at 1:30?
It does.
Yes. You don't have one here? Okay. Okay. The court is going to order the pre-sentence investigation report be done, but the clerk doesn't, we don't have them in this courtroom, so the court will enter that tomorrow, so that we will have that written order. And then, Ms. Schnock, do you want more than 30 days to file any post-trial motions, or is 30 days going to be sufficient for you?
I would request 45.
45
I have
days?
no objection to that, Your Honor.
All right. So, how about by the end of business on July the 21st?
That works.
All right? And then, Mr. Jones, anything else we need to take up?
Nothing from the people, Your Honor.
Anything from the defendant, Ms. Schnock?
No, Your Honor, thank you.
All right, we will be adjourned.
All rise. Adjourned.